I'm Jeb Butler. This is Matt Kahn. We're lawyers at the Butler Kahn law firm, and wanted to talk today about a recent $6 million settlement that we were able to obtain in a negligent security case. We're particularly proud of this one because for the longest time, the insurers for the defendant apartment complex said that it was only $500,000 in coverage. But lo and behold, we managed to do quite a bit better than that. What was the case about?
Sure. So this was a shooting case at an apartment in a high crime area. An 11-year-old was sleeping in her bed, and a stray bullet came in from the common area of the apartment and hit our client's daughter while she's sleeping in bed. And so this case was unique in that the owners of the apartment complex just knew about a ton of safety issues at this place. There were multiple shootings that had happened before our client's daughter was shot. There were hundreds of violent crimes that we argued were substantially similar and should have put the owner on notice that crime was a problem. And it was unique in that we had some emails from the owner with the security company that were literally talking about gang residents that lived in the apartment and were causing problems. And so it was pretty hard for them to deny that they knew that gang violence was an issue when they were writing about it.
Let's take a look at some pictures. So here, early on in the case, as we often do, we got right down to the apartment and started driving it around and talking to people. So here is a picture of the gates. When we pulled up, they're wide open. That's not because there's a car coming. It's not because the Butler Kahn lawyer who was doing this investigation had a pass. That's because the gates were broken. And they're always open in this apartment complex where the owners knew that crime was an issue. Here is a close-up picture of the chain on one of those gates. It is rusted. You can tell it's been broken for a long time. And Matt mentioned that this little girl was shot in her sleep. Even apart from that, there were pre-existing bullet holes in some of the walls from the gang violence in this community. This little hole here is actually a bullet hole, and then you can see it on the inside as well. This is the interior picture. You can see the bullet came through the drywall at that little angle. So a tough spot and not a reasonably safe place.
Mm-hmm. But liability wasn't really an issue in this case.
Mm-hmm.
And so, Jeb, why don't you explain sort of the position that the insurance company took at the beginning?
Yeah. So at the beginning, the insurer badly wanted to settle the case for $500,000. They said, "Oh, that's all the insurance we've got." And it was like this huge conglomerate run out of California. Matt dug through all the details and figured out who was who. But we subjectively did not believe that was true, even though they were telling us that was all the coverage that existed. And what they said was, okay, well, we've got this schedule of coverage, the insurance term, schedule of coverage, but it's written in such a way that when an assault and battery occurs, the maximum that person can recover is $500,000, and that's it. And they were being accurate when they said the write-down, as it's known, for assault and battery was just $500,000. So what we had to do was figure out if there was a way around that write-down. And in fact, there ended up being one. Matt will talk a little bit more about it later. But so one of the first things we always do when we have this dubious representation as to limited insurance amounts is get the full copy of the policy. It's amazing how many times they don't want to send you the full policy. They just expect you to roll over and read like the excerpt they send you. But we get the full one, read it, and then think about it. We'll do legal research as to the meaning in Georgia of every word in there that we think could matter. And then look at the facts, which in this case included not just the details of the shooting, but how the apartment complex had been marketed to the decedent's mother, our client, and to others who lived there.
Yeah, and so our investigation basically showed that this apartment complex was preying on low-income tenants. They would tell tenants, potential tenants, that this was a safe community, that there were gates, there were security cameras, they had security guards that would patrol the property and look out for tenants and their families. But it turned out that none of that was true. So, Jeb just showed a picture of the gate. that it was completely open. So yeah, there may have technically been a gate, but it wasn't doing what it was supposed to do. It wasn't keeping criminals out. It wasn't doing anything.
It's more like an invitation. Like,
Yeah.
come on in.
Right.
Nobody's watching.
And then, so similarly, the apartment complex had cameras all over the apartment, but none of them worked. They had been broken in a storm months before, and they just never spent the money to fix it. So while they may have technically been there, they weren't doing anything. And then finally, they did have security guards, but many times they weren't there, and other times they wouldn't really do anything to protect people. And in fact, the owners in this litigation took the position that they weren't even there to protect people. They were just there to protect property, which doesn't really make any sense. So we have an apartment complex selling a good or service under false pretenses. And so Jeb and I like to go on walks around the office and sort of talk about our cases. And we had thought, maybe there's a consumer protection statute that can somehow apply here. And so we dug into it and found the Georgia Fair Business Practices Act, which outlaws the behavior that we're seeing here, false representations that cause damage to consumers. And so there's just not a lot of case law on the Georgia Fair Business Practices Act in the context of negligent security cases. So we kind of had to take a flyer on this one. But the definition section of the statute included the sale and leasing of property, which is what we had here. And so we put together a demand that basically demanded the entirety of the insurance limits, the $6 million, and alleged that the harm wasn't, it didn't arise from an assault or battery. An assault and battery happened, but that was collateral to the misrepresentation that this place was safe when it really wasn't. And so we sent that demand and kind of just, we're wondering what would happen. So, why don't you tell them what happened?
Yeah. Well, here's a little bit about the place. We start. It's south of Atlanta in Griffin, Georgia. It was called Spalding Heights for a long time. Current name is Northside Hills Apartments. It's a big apartment complex. As you can tell, there's gates on the south side that are all open. And then here's their little webpage. I mean, it looks like a happy little place with no indication of crime. They even claim, and when you first go to the page, they claim to have a wait list. It says, wait list now open. Anyway, so we sent limits for the full insurance limits with all schedules, not just the little assault and battery they wanted us to use, which was $6 million. We actually did not know whether they would take it. We just kept working the case and getting ready for trial, but they did. The defendants accepted and paid $6 million to settle the case. We had happy clients and felt good about the representation, the legal work we were able to provide for a good family.